The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and I hope you enjoy this video. If you need some help, feel free to give us a call at 563-503-6910. That's 563-503-6910. Thanks for watching.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters as well as some family law. I practice here in the state of Iowa. Now today we're going to talk about illegitimate children receiving inheritances under Iowa law. The Iowa Probate Code states that a child inherits from his or her biological father if evidence proving paternity is available during the father's lifetime, or if the child has been recognized by the father as his child. Now, this recognition must be general and notorious, or it can be in writing. We've discussed establishing paternity in Iowa in other videos. The Iowa rule for establishing the paternity of an illegitimate child is somewhat unusual. This is covered by Iowa Code 633.222, which states that a biological child will inherit from their father if the evidence proving paternity is available during the father's lifetime, or if the child has been recognized by the father as his child, but the recognition must be general and notorious or in writing. In other words, the father must hold out the child as their own, or in some sort of writing form, admit the child is theirs. This was affirmed in an Iowa Court of Appeals case in 2014. An important consideration for fathers of children out of wedlock is that if a father wishes for an illegitimate child to take under intestacy laws, they should be sure to take steps to recognize the child as their own, specifically in writing. In the context of heirship, recognition means that the father admits and acknowledges that they have paternity. It doesn't have to be universal, but it is important to make some acts that hold out the child as your own. A contested heir must show their heirship by clear and convincing evidence. Someone contesting an illegitimate child's heirship must prove that they are not the heir by clear and convincing evidence. In other words, to refute the writing or holding themselves out, they must show clear and convincing evidence that the child is not theirs, not the father's. Now, what happens when somebody dies without a will in Iowa? When they die without a will, they are considered to be dying intestate. The Iowa Probate Code provides statutes governing intestacy laws that determine who may inherit from a deceased individual's property. The property is distributed by an administrator who is in charge of paying off the debts and winding up the estate. Some additional assets, such as property held in joint tenancy, life insurance payouts, or other things, might avoid probate. A surviving spouse will inherit all of the decedent's property if there is a surviving spouse. If there's none, but there are children, the children will inherit the property. In this scenario, if the decedent has a spouse, but the children are from another relationship, things become a little complicated. The spouse will receive half of any property, plus half of the personal property if the property is worth at least $50,000. Any descendants will receive the rest. If the spouse's share is worth less than $50,000, the difference will be made up from the decedent's share. Now, who inherits upon the death of illegitimate children in Iowa? In other words, if an illegitimate child passes, does the father inherit the money or the assets? Under Iowa law, if a child dies without a spouse or without children, their parents will inherit everything in their estate. Iowa Code Chapter 633.222 states, under such circumstances where paternity is established and the father is recognized, if the recognition has been mutual and the child has not been adopted, the father may inherit from his biological child. However, in situations where there is an illegitimate son and paternity is questioned, in this circumstance the child's mother would inherit everything. If the child's mother has died, the siblings would inherit the estate. As always, if you have any questions, feel free to reach out to us at our law firm. Thank you very much and have a nice day.
Hi, Kevin O'Flaherty again. I hope you enjoyed this video. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We have many geographical locations for your convenience, and we practice several areas of law. Thanks again for watching.